Welcome to one of the apparently more popular sessions of today's privacy camp. We are here because if you've been paying attention or participating even just passively in the public discourse in and around Europe, public discourses in and around Europe over the past years, you've for sure been confronted with topics like terrorism, fake news, piracy, hate speech, child abuse, illegal content, and all these things. These issues, they concern, of course, all of us, but we've seen them in quite a few instances actually dominating the public conversation and dominating regulatory initiatives that were then started in the EU and across its member states. We've seen numerous counterterrorism packages practically being rubber stamped across the continent. We are currently in the middle of a copyright reform in Europe that at its core wants to control how content gets shared on the internet. We are currently deliberating here in Brussels, but also through a few consultations in the member states, what to do about fake news and whether we need and how to control them. We are in Germany having since, did it come into force this 1st of January, I believe, a new law that basically forces social media to delete illegal content expeditiously. And in the UK we've had these pornographic filters and quite strict content and takedown rules for quite a while now. And the question is, have these measures been effective? What have their effects been? Have there been unforeseen consequences that we could or should have or did foresee? Should we continue engaging in this, or is it a dangerous path to go down? And how does this urge that we apparently have, either in public policy or in society, to control information, to control content, how do the systems we set up as a consequence of that interfere with online activity, and do these systems actually lead to surveillance of online activity, and do they have a interaction with our privacy? So here with me to discuss these different angles and to talk about the different initiatives today are Slavka Bielikova.
Yeah.
All right, good. From the Open Rights Group in London, in the UK. She did she did research on public perceptions of privacy, and is otherwise currently monitoring UK and EU legislation for the Open Rights Group. We have John Filipek from DG CNECT. He's working with the European Commission on several consultations and several deliberations around the fake news topic. And we have Glyn Moody, who is probably best known for a book called The Rebel Code, where he looks into free software and open source software and how it developed and its evolution and significance. More recently, he has looked into upload filtering, online filters and privacy in this relationship. And later joining us, she's still on the train, is Patry from Access Now, who is the advocacy director there. But let's start with Slavka and give you the word first to tell us about the UK.
Yeah, so I'm going to be mostly focusing on the current developments in the UK. Basically, following the 2017 elections, the Tory party decided that they want to make the internet, or they want the internet in the UK made the safest place for people to be online. And they decided that this can be achieved through various initiatives that are going to tackle hate speech, extremism, fake news, and they are going to remove also inappropriate child sexual abuse that's online, and there were a few more. So essentially they started drawing up a few initiatives here and there that are supposed to create this bigger measure called Digital Charter. We haven't really seen this Digital Charter yet. There is no text for it, even though the government keeps saying that they are working on it. And this Digital Charter is supposed to be a voluntary measure that social media companies and other companies can sign up to. There are several issues with this kind of a voluntary measure. First of all, it's not really clear what the enforcement system is going to be and what's going to happen once these social media companies are going to abide by the, let's say, code of practice that's going to be given to them under the Digital Charter. And that brings a whole lot of other issues. Then also there is the issue of fines, because the Digital Charter is going to be voluntary, but the government is saying that if you don't take down this inappropriate content, we are going to fine you. So it is quite likely that most of these companies are going to be taking the content down, and they are going to be doing it more than they might have been doing it, just to avoid the possibility of getting fined. Yeah, so this is pretty much what I'm going to get into today.
All right, thanks. We'll do a round of initial statements, and then we'll go for some questions, and then we'll basically be switching back and forth. Next is John. He will tell us a little bit about the process around how the European Commission plans on looking into the fake news topic right now.
Thank you, Dimi. I'm pleased to be here today. I'm at the Audiovisual and Media Services Unit of DG CNECT, and have been helping the DG organize an initiative on fake news and disinformation online. I'll tell you a little bit about the process. We're in the information gathering and reflection stage now. Don't have conclusions for you, but thought it would be useful to give it a status report on what we're doing. Fake news, of course, has crystallized as a thing in the public mind over the last year or so, and in particular, there have been concerns about harmful impacts on public discourse, on the functioning of democratic societies, and other concerns as well. The fake news was highlighted as a concern in President Juncker's mandate letter to the new commissioner, Maria Gabriel, and was also the subject of a resolution by the European Parliament calling on the Commission to look into this concern and see whether there were actions that should be taken. The Commission launched its initiative on the 13th of November with 2 online questionnaires that are available and are still open that people can choose to contribute to if they wish. They're running through the 23rd of February. One for citizens, one for companies, legal entities. In addition, we have commissioned a formal polling of citizens in all the member states concerning their views on fake news, whether they have encountered it, what they consider the principal concerns to be, and whether fake news has, in their view, impacted them or society. On top of that, we've had 3 structured stakeholder dialogues. There was a multi-stakeholder conference in the middle of November. Representatives from the whole class of stakeholders, platforms, media groups, broadcasters, civil society, academics were invited. We got inputs from this conference. In addition, we had a workshop for the member states in which the authorities from the member states came and outlined what, if anything, was being done in their respective countries to deal with fake news and what they envisioned doing in the future. There was also a meeting of the Commission's expert group on media literacy, in which the Commission presented its initiative. Finally, the Commission has convened a high-level group of experts to advise it on fake news. 39 experts from the different economic and social spheres concerned, platforms, again, news media, broadcast media, civil society, academics will be advising the Commission on the problem and seeing what sort of measures might be taken to counter it. The high-level group's report will filter into a communication which will be adopted by the Commission in the spring. So that, in broad strokes, is what is a description of the consultation process that we are carrying out at this stage.
All right, thank you for now. And well, Glyn, and your initial statement.
I'd like to talk a little bit about the tension between copyright and the internet. If I wanted to be provocative, I'd say on the one hand you've got copyright and on the other you've got the internet, and you get to choose one. And that tension between copyright and internet has been present for at least 20 years when the copyright industry has attempted to tame this internet thing. And the latest manifestation of that, I think, is really important. It's the copyright directive that's currently going through the system. And there are various problems with it from the point of view of people in this room. And I'll focus just on one, which is not only the worst, but also one of the worst attacks on the internet there's ever been. This is Article 13. And it requires basically everything uploaded to major sites that have uploaded material to be actively filtered. And that's not just things like YouTube, which is an obvious place where that will happen, but even Wikipedia and GitHub. So programming sites, any kind of site like that will be affected. The rationale, one of the rationales, is to tackle unauthorized uploads. The copyright industry is always complaining that unauthorized uploads are ruining its business model. Unfortunately for them, the EU did some research which showed that that simply isn't true, and rather mysteriously that research was never published. A cynic again might say that's because they didn't get the answer they really wanted, but there's no evidence in fact that in most industries that unauthorized uploads are actually harming the sales. The other rationale, such as it is to tackle something called the value gap. This is a really clever piece of propaganda that the copyright industries have come up with, and I strongly urge you never to use the words. It's not about a value gap, which gives the idea that somehow Google is stealing money from all those poor starving copyright holders. It's actually an innovation gap. It's the fact that the copyright industry was too lazy and too stupid to take advantage of the internet, and other companies came in and made huge profits. And now the publishers and the music industry are basically whining that they haven't got all that money because they didn't take the efforts to do anything about it. So what they want now basically is this Article 13 to throttle those successful companies and to use law to give them back what they should have got themselves. This upload filter is very interesting because the use of general filtering, which is what this has to be, if you're going to filter for unauthorized materials, you have to filter everything. You can't do it selectively, it's just not possible. So as a general filter is specifically and explicitly forbidden by the e-commerce directive of 2000. So the European Commission is trying to go against its own legislation. To get around that, they're saying, well, actually, this will be voluntary. It won't be a law. You can do it if you want to, but if you don't do it, we'll bring in a law. There are also deep problems with the General Data Protection Regulation, because if it isn't compulsory, if it isn't a law, the General Data Protection Regulation, which comes into force in May, says you can't do these kind of non-necessary filtering. So either it's necessary, in which case it goes against the e-commerce directive, or it's not necessary, and it goes against the GDPR. So I mean, the European Commission's in real trouble there. But a couple of other things I just want to quickly mention. This is a classic case of pixie dust. The European Commission has a problem, and it thinks that if you just sprinkle technology on it, then all those problems will go away. They're doing this with crypto too. They want to have backdoors in encryption. The experts say you can't do that. The governments around the world say go away and try harder. They just won't listen to the fact that there are technical problems. And it's the same with upload filters. You really can't bring in upload filters that do what the Commission want, where you don't actually damage the whole process of the creativity of the public, the free expression, the free speech. You're actually moving to a situation where you actually bring in prior restraint, where you assume people are guilty until proven otherwise. So the whole legal system is being turned on its head simply because the copyright industry wants it. So just two quick suggestions. One is maybe we should spend more time educating the legislators that pixie dust doesn't work, because then that particular process, an attempt to force through things that can't be done won't be done. And the other one is that many in the publishing industry obviously understand this. You know, they know that it isn't possible to ring and upload filters that won't overblock, that won't shield freedom of speech, and that don't make user-generated content impossible. But for them, those are features, not bugs. This is what they actually want to do.
All right, thanks. We've had quite different approaches, as you can see, to what I hope will come together in the end as a joint topic. So we've had the UK, we had fake news, we have copyright, and now I give the word to Melody, Advocacy Director for Access Now, working on, what was it, campaigns, communications, advocacy, basically on everything globally. And I give her the stage now for her initial statement.
Sure, and apologies for being late, but thanks to everyone who was live tweeting, because I was able to follow what was going on in the room as I was at the train station and in the taxi. So yes, I work at Access Now, and actually we work on like various issues related to content removal and blocking and filters. And one of the main issues, as we see the multiplication of legislative attempts to regulate online content, is indeed some of the existing contradictions, whether it's by the EU Commission itself or by member states, but also the possibility for setting very poor precedents, as we saw as soon as Emmanuel Macron announced a possible fake news legislation coming up. Brazil followed suit, same with Italy earlier today, I think, or yesterday. Also announcing some possible fake news legislation. And when speaking to the EU, it has happened in the past that people were saying, oh, this kind of regulations, like, it's not our fault if other countries that don't have our democratic safeguards and that don't have our standards in terms of the rule of law and so on, copy our legislation, then misuse it. But then, yes, it is. You are setting a precedent, and especially in the field of internet, when you see also some companies trying to implement global content removal for sovereign or domestic legislation, that is a problem. And so we've seen this especially in the area of hate speech, because the EU Commission says, okay, illegal hate speech, there is defined in EU law as incitement to hatred and discrimination and so on. But if you look at member states themselves, they have different hate speech legislation, and content that can be illegal in one state content that can be illegal in one state can be legal in another state. That's the case for Holocaust denial, for example. So how do you reconcile all the different definitions of hate speech to begin with, but also of extremist content, which usually you don't even have legislation, or you don't even have an agreed upon definition of what constitutes extremist content that should be removed. So that is like slightly different from the copyright issues that we don't really touch upon, but in terms of what is and what is allowed online and what can be removed or taken down or blocked, especially when you start talking about automatization or AI generated blocking and filters, I don't think there is any case study of this system working without completely chilling free speech, without provoking over-compliance by intermediaries and internet providers. So these are all issues that have not quite... Of course, we need to address the issues of online harassment, extremism online, hate speech, fake news, and so on, although I hate this term. But these are all issues that we need to address, but how can we make sure that we address them by setting up appropriate standards and without either blaming the internet, because it's way too easy, and increasingly it's actually like a political move. You just blame the internet and you say it's all the fault of the social media companies or the giant techs, and increasingly you also blame fake news, like, oh, our democracy is in danger because of fake news, our democracy is in danger because of the internet, therefore we need to block or control or restrict what is available online. And that is actually very often undermining democratic principles, as a lot of the solutions that are pushed forward operate in very untransparent model, outside the rule of law and are delegating powers that should remain of the sovereignty of the state, and especially of the legal procedures to private companies that are not necessarily accountable to citizens.
Hey, thanks. Are there any questions already from anybody in the audience, or should I give you a few more minutes to think about it and continue with my own questions? All right, Asta?
Yes, hi, my name is Asta. I was maybe wondering with Article 13, many people, like many would actually argue that this is not censorship because it is just filtering of copyrighted material and therefore it's not censorship. But in reality it is censorship. Just because it's justified by copyright doesn't mean any less censorship. But maybe, Glyn, would you agree with me that what we is basically doing is that we are trying to develop mass surveillance censorship techniques that are not in the hands of government but private companies? And would that not be delivering and actually putting certain kind of power, the right to actually censor, into the hands of private companies, which would actually be quite terrible in my opinion?
Do you want to repeat the question, or shall I? I'll repeat the question. So the issue is whether we're creating something that's going to put power to censor in the hands of private companies. And in fact, we know that's the case because it's already happened. In the UK, the main telecoms company, British Telecom, created a filter mechanism which it said, when it put it in place, that it would only be to filter out child pornography. It would not be used for anything else. And guess what? It's now used for everything else. Once you create the mechanism for censorship, whatever the justification, whether it's terrorism or child pornography, it is always abused because the other people that want to use that mechanism say, well, since it's there, it won't really matter if we use it for something else. So once you put it in place, it is always used, and it's naive to think otherwise, I think.
All right, thanks.
Wendy Grossman, would you say that the Internet Watch Foundation is almost an exception to that because they've had the pressure, but they've seemed to have resisted it so far?
Who, me?
No,
You're me, sorry. I
sorry, because he was talking about the UK.
I mean, they seem to be doing quite a good job, but I know some people aren't totally happy with how that's going. So I don't.
Well, some people are always.
Well, that's true, but it's still the case that the mechanism is there for censorship. It's more the technical means rather than where you've got an organisation. So I'm not so worried about an organisation as such as when you build the boxes that can actually take stuff out. That's when you've crossed a line and you can't go back.
See no more. Well, okay.
I would have a question for John. You mentioned in the beginning that the Commission is very much the kind of reflection process for any kind of whatever it is that is coming out of that reflection process at the end. Are you also looking into the situation that we have in Germany right now? Because some countries seem to have gone ahead already. Germany would be the Netzdurchsetzungsgesetz.
Sure.
DG. Are you looking into that, and do you have an opinion about how that works right now?
Well, the question is whether the Commission, in connection with the fake news initiative, is following developments in the member states, and yes, we are. It's in our view that Germany and the announcement by President Macron in France, these sort of signal that these are important political issues. So we will follow these developments closely, and of course, from our perspective, we are very interested in making sure that there is sort of a coordinated EU approach. But beyond that, I really can't comment for the Commission.
And personally?
I'll pass.
Thank you.
Hi, my name is Fanny from Access Now. My question is what definition the Commission is using for the fake news expert group for fake news, and if there's no definition at the outset, in lack of a problem definition, how were you able to find the best experts to contribute to the discussion?
So, just to repeat the question, the question was: is there a problem definition that the Commission is working with for the high-level group fake news, and in light of that, how were the members chosen?
Okay. Well, there isn't a specific problem definition. I think you highlighted a very important issue. There is a lot of discontent around the term fake news, which many believe it has been appropriated and rendered meaningless. It's sort of a term of abuse for critics for media. Now, as regards the high-level group, we have the high-level group has established a number of subgroups, one of which will be charged with defining the scope of the problem and the sort of applicable legal principles that will that should be taken into account. Beyond that, there are a number of subgroups, each devoted, each focusing on the platforms and roles and responsibilities of the platform. So, the subgroup on problem definition and fundamental principles will attempt to arrive at a definition of the problem, whether they decide to define fake news or perhaps suggest another term that could be used as a handle. I can't say, but there is a focus on defining the problem, which is important because if measures are proposed for a problem that is poorly defined, then there is there are problems, risks of abuse by public authorities and others.
Can I have a follow-up?
I guess, yes.
So just for full disclosure, this is now applied to be on the expert group, so I don't want to be for PMI. So just so you guys know. And my question is there any ways for the public, beyond the public consultation, to contribute to the work? Is there anything public about the work of the expert group? How can journalists, advocates, anybody support the process to achieve a good outcome?
One thing I would recommend that you do is consider making a submission, the online submission. I understand that there will be public dialogues organized with the Commission in some of the member states through the representations. That's another potential avenue, and I think those would be the two principal means.
Thank you. And well, just for the record, the question was what other ways, apart from the working group, are there to contribute to the process? Anybody else? All right, the hands are getting tired, and I get to ask one of my questions. So, Melody, you spoke last, but you'll get your question first. You touched upon the fact that there are several, well, in different places there are different conceptions of hate speech. Well, could you give us a few more examples of that? And do you think there is a way to reconcile these different, different conceptions of hate speech? Because in the end, we need a standard, I guess, if we have one internet.
So it's extremely complicated because also legislation changes and you also have cultural changes sometimes that vary from country to country. So in countries where you still have blasphemy law, for example, blasphemy laws are usually as part of hate speech restrictions in those countries. Countries that have indecency laws, that would always be also like comprised as part of hate speech laws, or that have like defamation criminalization, which is an attempt. I know that lots of civil society groups have also tried to do some work to decriminalize defamation. So all of this is usually as part of one umbrella legislation around hate speech. And it is very difficult to find some common grounds because we're not all at the same level. There are lots of disagreements, and also there is a lot of conflation between hate speech and hate crime. And when some of the UN standards consider that illegal hate speech is any speech where there is an intention to incite violence, discrimination, or hatred, again, that definition of incitement can sometimes be interpreted differently, and you've got different thresholds to assess the incitement, namely if it's credible, if it's immediate, if it has like a possibility to if there is intent behind, and credibility to achieve violence or hatred. So depending on the definition and where you are in the world, you don't apply the same threshold. You don't even have the same definition about what you consider hate speech or not. So you understand already how within one country that can be problematic. Imagine applying this at the global level or even at the regional level, but with consequences that go global, which is the case for the internet, especially as more and more countries who legislate about content regulation are trying to have the decisions implemented not just domestically, but beyond borders. And we saw this for the right to be forgotten, for example, when the French data protection operator is trying to force Google to not just delist results for google.fr, but also for google.com and for like any kind of Google search engines. So that is one of the biggest issue, and I'm afraid we don't really have an answer, especially when the solutions to what's, even if we manage to come up with a definition of hate speech that would satisfy everyone, when the solution to hate speech is censorship and is delegating powers that should be decided by, judges that are delegated by private companies, that is an issue. So usually, even civil society themselves don't agree on a hate speech definition. Some people take a really like a First Amendment model, which is like only incitement to violence and with like a very high threshold. So if it's like credible, imminent. Some are a bit more less strict and take a lower threshold. So it is difficult, and also hate speech now doesn't mean anything. Do you include extremist content? What does extremist content? Does it mean like terrorism propaganda? Does it mean incitement to terrorism acts? And again, like propaganda, what do you mean? Is it like just sharing lots of information about something that is illegal, or is it inciting people to take up on arms and perpetrate terrorism action? So that is one of the main issues, and something that we have to take into consideration, which is why usually we ask for legal authority to make that assessment instead of asking private companies to make that assessment.
All right, so would you, just a short follow-up question, so you would say that our inability to come to a, let's say at least European or global definition of hate speech is impeding us from actually working on solutions?
No, I think we can work on solutions. I think the problem is that when we're trying to build a definition, it is because we are pursuing measures that may not be adequate. So instead, if you work on a definition, and instead of immediately considering that you're trying to remove your own responsibility and delegate it to private companies, instead if you're looking at, okay, there is an issue of, harassment online, let's say, or, like lots of marginalized communities that are marginalized or attacked offline are also the first communities affected online, women, LGBT, activists, and so on. So of course we need to address hatred, discrimination, and violence that may be targeted at them online. But when you look at it, actually, like having really strict censorship policies is inefficient and hasn't proved efficient, and yet it has been banned online and offline for many years now. So I think we just need to take a step back from the systematically, we need to take down this content, we need to filter this content, we need to block this content, and we need to ask private companies to scan all of the content, make the assessment whether that is discriminatory, whether that is inciting hatred, so that they can remove it. If instead you look at other possible measures, some of them that may not necessarily be, a criminalization of such content, to look at solutions. And I think the same for fake news. You can't just ban fake news because there is no such a definition of fake news. It happened that Twitter was just banning satirical accounts at some point, and you're just like, well, is this helping democracy, and in this, helping citizens to build critical thinking? I don't think so.
All right, thank you. So I guess we're back to platforms and companies trying to handle well, we don't know whether it's illegal, but let's call it unwanted content. And maybe back to you, because you touched upon this earlier. There are several, well, basically there could be like two main approaches how companies try to handle this. People, algorithms, or let's say a third one, a hybrid one of the two. What would you say are the advantages and disadvantages of those?
Well, I think, first of all, before we start thinking of these kind of solutions, as Melody said, we really need to get the definition right. And currently in the UK, the government doesn't even have it clear that there might be a difference between hate crime and hate speech. They are conflating the two. And then there is absolutely no definition of extremism, or whether extremism also includes the terrorism propaganda, whether these things are separate. So I think that's the first step. That's what we would need to do first. And then when we are looking at the companies and how they are tackling this, well, clearly we know that there is an issue if there is only an algorithm trying to take care of all of this. There are going to be excessive takedowns. There are going to be takedowns that are going to be missing. So probably the best would be a hybrid one, because I cannot really imagine any of these social media companies just hiring enough people that would be able to review all the content online. So we would probably need a hybrid one, and there is a question what this hybrid model should look like what should be the human involvement. And I would appreciate actually input from everybody. What do you think that this human input should look like? Would it be smart to have some sort of a panel of people that would be vetted, or should it be just employees at the company that should be looking at this? I don't know. Would anybody have any ideas?
All right. So a question back to the audience, if anybody wants to share something on this. But we'll start with you in the blue shirt, and then it's the lady behind you. Yes.
Thanks. Winston Radigan from Emory University. I was listening to what Melody was saying, and I think it points at a more general issue of how our values are really relative, and sometimes we are very much focused on Western values, let's say, that do not necessarily apply in other countries and systems. So the thing I'm researching at the moment, is dating apps. And for instance, now Grindr, which is the main gay dating app, has been built by a Chinese tech group. And China passed some months ago a law that defines homosexuality abnormal and therefore bans all homosexual content online. So how is that going to play out after all this data about gay dating apps are now controlled by a Chinese company, for instance? For us, it's something unacceptable, of course, considering homosexuality as abnormal, but that's the law there. So that's an issue that relates not only to hate speech, but more generally to regulation of the internet being intrinsically global.
Can I just say something on that point? Because I think it's an issue that people need to think about now, is the fact that Chinese computer companies are basically going to buy the world, and that means they're going to be running the internet soon. So companies like Alibaba and Baidu and Tencent are all going to be running large chunks of the internet. As you rightly say, they have different values from ours. And within the context of the Chinese internet, they're already imposing those values, what you can and cannot say. What happens when they start taking over parts of the internet outside the Great Firewall of China and start running bits that we use? And that's something we need to start thinking about now, because it's going to happen. It's already starting to happen, you say, with Grindr.
All right. We had another question here, and then it's you.
So my question is, refers to Article 3. My name is Andrea, and I come from Opting for Rights. My question is regarding Article 13, and then it kind of fades a bit into the other legal frameworks that touch on content filters. So imposing general monitoring of content is illegal, as the Court of Justice also mentioned in cases of netlaw. And also a lot of copyright lawyers that joined our meetings on the topic mentioned that, or pointed that content filters are are nowhere mentioned in the actual Article 13. So why are you even telling me you're, paranoid about it? And then again, Article 13 does say that platforms should take effective measures to prevent the availability of copyrighted material, remove it expeditiously, quite fast, and ensure that future availability of this flagged content is blocked. So also Ansip himself, the Vice President of the Commission, did offer Audible Magic as a solution to this, which is a content filtering solution. So my question to it is content filters also in the copyright, in the proposal for the copyright reform, but also in the Audiovisual Media Services Directive, the proposal for that, and other legal frameworks. Is this a voluntary option, or are content filter, automated content filters a offer that cannot be refused?
Yes.
So
It's both. They want to have it both ways for the reasons I mentioned, that they can't impose it because of the court ruling and because of the e-commerce directive. But you mentioned Audible Magic. This is something else that hasn't really been brought out. That exists. There's also the YouTube filtering system, which costs $60 million to create. Again, this is the pixie dust stuff. The Commission thinks that if you just spend a few $1 million, you can come up with some system. But you can't enshrine the complexities of copyright law. However, whether you have people, AI, combinations of it. I mean, again, it's this lack of technical knowledge which I think we need to address, because they think that it can be solved somehow. And again, the fact that they say, well, it doesn't have to be filters. Well, how else can you make it an effective measure? I mean, what else is there? Magic, you just sort of pick it up by random. I mean, again, it just doesn't make any kind of technical sense because they don't worry about that stuff.
Yeah, and and actually even related to this, but even flagging mechanisms also have flaws and have been used repeatedly now in many countries to remove legitimate content, and the lack of transparency, but also the lack of appeal and remedy mechanisms have made it possible for thousands of content online to disappear when it was perfectly legitimate. So these are also possible solutions that we need to be very wary of, because it has been used. You even have had countries that were creating accounts and you had like civil servants whose job it was to flag dissident content as copyright violation or as terrorism propaganda, when actually it was perfectly legitimate content that was being massively flagged as an attempt to play with the algorithm, because a lot of it is automated, is based on the number of flags that have been received. And that's also one of the reasons why the internet referral units that have been installed in many countries, but also at Europol, for example, are so problematic. It's because it all operates outside the rule of law. There is no transparency about it, and it is a way for many countries to actually circumvent the good procedure, which would be to go to a judge and get a court decision on content that you think is illegal and have it removed. Instead of doing this, you just allege that it's illegal. The content is removed without a decision of a judge. There is no judicial oversight. It's not transparent. Users are sometimes not even notified, and that is highly problematic, and that has been a cause for abuse.
All right, so sorry, you were first, and then us again.
I just wanted to build on what he said about how, for example, copyright maximalism, it might be abhorrent for other jurisdictions as it is abhorrent for us to talk about the Chinese situation. So I think also in the global origin, people need to check their assumptions on what is, oh yeah, copyright infringement, definitely that's something bad. Well, that's not necessarily something that is shared across the world. In the same way that discriminatory or censoring gay dating apps in China it's not a value that is shared. But also, on that, my question was going to be about the jurisdictional and the territorial application of these filters, because this is a discussion that we're having on the global removals that some data protection authorities are trying to do with the regulatory bodies' interpretation of data protection, which is not shared also universally, and they've been resisted in other parts of the world, in Mexico, for example. So I'm also curious about people discussing filters in European legal institutions and legal context, how they're thinking about the territorial application of their decisions. If they're going to allege that a decision taken by a European institution should be enforced on the whole internet or only on the European internet. And whether this balkanization of the internet is something that we want or not.
So what does Europe think of the territoriality of the rules it creates to sort of control content online? Any takers for that?
I mean, just to pick up on one point that you made is very important, that modern copyright was invented in 1710 in England with the Statute of Anne. It was then built on by the Americans over the last 150 years. So you're absolutely right, it's basically an Anglo-American project which has been imposed on the rest of the world, typically through trade deals. And those same trade deals will try to extend extraterritoriality into all those other markets. So I'm sure they'll try to make them global, you're absolutely right.
And that's how the DMCA model works already.
Yeah,
It is an American legislation that is being implemented internationally.
All right. Are you happy with that answer, or you not? All right then. Yeah, Asta.
In Article 13, it is, if I just make quote it, that it should say that those measures, such as the use of effective content recognition technology, shall be appropriate and proportionate. Appropriate and proportionate, what does that really mean when you are trying to scan something or filter something on a platform? Would you say, it would be interesting to actually hear from both the European Commission at least and maybe Mr. Moody, what is proportionate and appropriate when it actually comes to filter content in terms of privacy, because it's like, privacy camp, and also in terms of actually finding the balance. Some people have actually compared this to the scanning that you actually have to go through when you're going through security. But I think that is a matter of life and death. Copyright is not necessarily a matter of life and death. This is a fiction. All law is in a way something that we make, and this is an environment that we have made consciously since 1703, the Statute of Anne. So, is it appropriate and proportionate to actually scan every single item that's uploaded on our service platform? Does it make sense?
Just a caveat, because I promised to do this. So John is from DG Connect here, but he's working in a department that's basically now working on fake news. So he's not really in a position where he can say what the DG Connect's thoughts on the copyright reform were. But other.
If a similar proposal would actually come because of fake news, in order to actually scan for fake news, everything that would be uploaded. We can actually just, how far are you supposed to go in order to actually ensure copyright, ensure that there are no fake news, ensure that there's no pornography?
Well, you're articulating very broad legal standards, and I think it's hard to get more specific than that. Appropriate and proportional and broad legal standard. These provisions of these directives will be transposed into national law, which may provide further specificity. They will be applied in court cases in which courts can interpret them and try to balance. We're dealing with enormous, vast quantities of content. It's not an easy issue. I would think you would have to look case by case, and that's about as much as I can tell you. I'm not familiar with the guidance on these standards that you're citing.
Speaking as a cynical journalist, I think that it's basically a fig leaf, so they can point to it to say, look, we are looking after the privacy aspect. The reason I say that, and the reason I'm cynical, is because I've seen it before. in the anti-counterfeiting trade agreement, which happily died in 2012, they had exactly the same protection for privacy when they were trying to do exactly the same thing. So this is a standard ploy that you do something awful and you say, oh, but you've got to do it proportionately, without actually saying what that means. So yes, the local courts will have some views on that, but I don't really think it means anything useful.
Just maybe since we're digging in a bit on 13, to share a little experience I've had back home. I'm from Bulgaria, so I spoke to some Bulgarian platforms on, this upcoming legislation and, the fact that they might have to implement some sort of upload filters, probably, or content recognition mechanisms that delete unwanted content. And then, their immediate reaction was completely different to what I've heard from, let's say, platforms from Western Europe. They're like, well, can't we just write a very bad algorithm that wouldn't recognize anything to delete? So, basically, in the deep east of Europe, the approach to legislation is a bit like, well, if you don't like it, don't implement it well. And,
very pragmatic, I like that.
You have no problem, but, well, this really struck me as something, because, we're wondering what to do with this here, and then, people were there, well, fine, we won't implement it well. Which is sad and funny at the same time. Any other questions from the audience? You again?
Because you did brought up platforms in Bulgaria, their perspective, I'm pretty curious to find out from all of you, what is your opinion that content filters, what is their effect on SMEs in the IT sector in Europe, perhaps in the context of Horizon 2020, that is a framework for a great digital single market, open knowledge, and so on and so forth. What is the effect that these legal, technical, administrative burdens in the end have on the SMEs in the IT sector?
Any takers, or should we just...
No, do you want to say something?
No, please.
The question is what effect that content filters could have on SMEs in Europe. And I think this is an aspect that the Commission hasn't really considered. I've already mentioned that it will have a big impact on the software repositories like GitHub. So it's going to be very hard for smaller companies to actually upload some of this stuff because they're going to be filtered all the time. And then you talked about the Horizon projects. Basically, you're placing obstacles and red tape on SMEs at a time when the European Commission says it wants to reduce it. So again, it's contradictory in terms of its stated aims. This will place the European software industry at a great disadvantage compared to America and particularly China, neither of whom will have anything like this. They will just do whatever they want. So why we make it so hard for European companies to compete? They won't stand a chance. There will be no big software companies coming from Europe if this goes through, because the obstacles to doing so will be so great.
My favorite scenario in that is that if such a provision really comes and you as a platform are basically have to have some sort of content filtering, that just as we have Google Ad services now that are very easily integrated into your own site, there will be another service by Google called Google Filter that you can easily integrate into your site, and they will do this content recognition for you.
And they will all be American and possibly Chinese companies determining what we can and cannot say online.
Or if you want to do a bad job, it will be a Bulgarian company.
Yeah, well, I would vote for that.
But kind of related in how we approach solutions, for example, to regulation or addressing controversial or problematic content online, is the fact that at the moment we place a lot of burden on the companies, and indeed sometimes companies have a role to play and can play a part in the solution, but we are also seeing lots of power delegation to companies. And what I haven't yet seen as a proposal, for example, is when NetzDG asks company to remove content within 20 hours of being flagged because they're saying, oh, we need to act very promptly, etc. But why don't we train lots of judges and create special units in countries that can actually assess material in a very rapid way, and probably much better than a private company could do? And that way you don't place all the burden on companies, whether they're big or small, but instead you create you create safeguards that are within the state that are that have the responsibility, like the judicial responsibility to assess that content. Somehow these proposals haven't been pushed through. We're looking at, okay, let's just like let the companies be like the judges, the jury, and the executioners, but we're not looking at nationally or even regionally. How can we train judges to assess this kind of content? How can we train more judges and have like specific units at the state level who can assess that content with the lens with the domestic lens, which would make it much easier than a foreign company with maybe different standards or not as familiar with the legislation of a country.
Was it Brazil that I read about, that during election time in Brazil they have basically a court that is open 24 hours a day and that online companies can approach about blocking certain content or not? I'm not sure if anybody has heard here about that.
Yeah, I'm not in favor of that.
No, but I mean, it would be such an example of having a specific court for online content.
Yeah, I mean, it's interesting. It's not like I don't want like new like censorship boards being created in lots of countries and just have judges. And actually, one of the issue with Brazil is that while they were like so forthcoming and everyone had so many hopes on Brazil with Marco Civil and lots of protections for citizens and internet users being passed through Marco Civil, but at the same time you still had people in Brazil being arrested for blog posts. You had journalists being banned from using social media platforms because they had criticized high-profile businessmen and so on. So we also need to be careful about sometimes even some judicial decisions when there is actually a gap between the human rights standards and understanding of freedom of expression and privacy rights in such countries, which is why it is such...
But at least it's the rule of law,
exactly,
isn't it?
At least there is a rule of law, there is a very clear mechanism, you've got a remedy process, you've got an appeal process, so that's why like annoying NGOs are always pushing back to know this is like of the authority of a judge and this should operate with judicial oversight versus let's have the companies
sprinkle pixie dust.
Do the work. Yeah.
All right.
So I think, Mr. Moody, you just called Article 13 one of the worst things to happen to the internet. I was curious as to why you think that even within the digital rights community there seems to be so little sort of work being done on this topic. It seems maybe it's I don't know if you have any ideas.
I agree. It's something that's puzzled me too. Whether it's simply that the governments have taken advantage of the power of technology and have kind of repurposed it for what they want to do, and the people in the kind of digital rights community are on the back foot and are desperately trying to cope with that. I don't know, but you're right. I mean, we do need to do more in that field. I suppose there are so many challenges at the moment. It's just very hard knowing where to focus the power. But
yeah, maybe some people don't see the direct connection. Can you like really point out how exactly copyright content filters are a problem for profiling and privacy?
Well, copyright filters basically look at everything put online. And so it's just a surveillance machine. And as I say, once it's set up for any purpose, it will always be subverted for other purposes. So unless you're super happy with a surveillance machine that looks at everything you do, I suggest that a surveillance machine allegedly just for copyright infringement isn't actually going to be something you should accept. Because there's no such thing as a kind of specialized copyright surveillance machine. It is total surveillance. And that's the basic problem. All the other problems that flow from surveillance will be in that system.
And just to expand on your last point, total surveillance by private companies happen more often than not. American companies, US-based companies, that doesn't necessarily serve European interests because it will be so difficult for European companies to actually compete with that. So it will be Chinese or American companies that will be actually providing the filtering service, making the decision what can actually be uploaded, doing the whole filtering. Will this not undermine national security in Europe?
Yes, inevitably. But people aren't joining the dots here. looking very narrowly, because the copyright industry, for some historical reasons, is very powerful in the European Union and also in America, but in the European Union, and is driving policy in this area. And basically, this is being pushed through to the detriment of the internet, to the detriment of digital rights, and you're right, to the detriment of national security, because we will lose control of the internet in Europe. And whatever other safeguards there are, that's such a major loss that really, the European Commission should be considering that.
All right, maybe I have like a little bit of an unscripted question here. Across the field, be it copyright, hate speech, well, let's say sexual content, fake news, whatever you call it, I guess we can all of us agree. I mean, we disagree about how to define it, but we agree that there is some, well, let's say at least undesirable content that exists in this world, and some things are dangerous or should be looked at more precisely. And we cannot here even agree amongst, I guess, people who otherwise agree on a lot of things on a definition of these issues. We don't trust our governments to basically set the definition for us, even in countries where we would say we would have stable democracies and high trust in institutions. We don't want the institutions to make the calls for us what the problem is exactly. And we don't trust private companies and monopolies to make the calls for us. So what do we do? I mean, how do we square this circle? Who does what? Or nobody does, or will nobody do anything, and we just see what happens?
We use judges. I mean, I love judges. They're my favorite people.
But even judges need like sort of a framework
in
order to be able to define.
But I think they're the least worst option. As you rightly say, you can't trust governments, you can't trust companies, but the judicial system is the only thing we've got. At the moment, we're undermining it. If we put in these filters, we're saying there is a presumption of guilt, and you take down stuff if you're, at all unsure. That's not how a legal system should be working. And yet we're not fighting this. I mean, this again seems to be a fundamental issue for digital rights that we're not fighting, and we should do. We should do it. The system that has worked for 2,000 years-ish. The judicial system is the way to do it. We're not doing it with this. It's crazy.
Yeah, and the excuse that the judicial system is too slow is a bad excuse, because if you consider that there aren't enough judges or they're not reactive enough, you just invest in training more judges, and training them really well, which means that you don't want them to be like robots who just systematically order takedown requests and blocking orders, but you train them well so that they understand the different threshold that needs to be implemented for removing content. You understand also that when we set up legislation in the EU, especially legislation that have effects online, we are setting a precedent externally. And do we want China to use the same legislation? Do we want Russia? Do we want Bahrain, Turkey? I mean, we see like fake news laws or laws that ban the spreading of lies and untruth. There is such a law in Turkey. There is such a law in Bahrain. Who is victim of this law? Human rights activists, political dissident. We need to be extremely careful, and we can't shy away from targeting difficult issues by looking for miracle solutions or magical solutions, or being like entering this political game of, I'm going to remove all responsibility from it, instead of investing in education, teaching kids like critical thinking so that they don't believe, fake news or like very smart satirical content online. It's way too easy to put all the blame on the internet, the dark web, the trolls, because politically, yes, it's smart. I mean, maybe if I was a dishonest politician, I would do the same, but I don't think that is strengthening our democracy. And that's why I'm curious about also like the work that will come out of the European Commission expert group on fake news, because so far most of the initiatives that I've seen around fake news have been heavily flawed and not encouraging critical thinking, but fighting over who is the arbiter of the truth or not. And that is always dangerous. I mean, as we see it in the US, Donald Trump issued an award, a fake news award. So if he can be the arbiter of what is true or what is not true, and other countries start to do the same, that is really concerning and dangerous.
So the Commission has a good chance here to show that they're better than everybody else into doing it better. Then maybe one last question for you. Was it Vice President Ansip who said fake news are a serious problem, but we're still trying to figure out this phenomenon. And I'm not even sure you can answer this, but
I'll respond to that and also
right.
respond to some comments that Melody has made. Fake news is a multi-dimensional problem. Obviously, it will require multi-dimensional solutions, public authorities, courts, the stakeholders, platforms, news media organizations. It can't just be attacked from one perspective. And I know that the Commission is taking this perspective on the problem. It's looking for inclusive solutions that will involve all stakeholders, and is not. There has been no instruction to define new categories of illegal content. There are ways of addressing these problems that do not involve restricting content. You've mentioned some of them yourselves: investments, media literacy, other supporting journalism through various mechanisms. So restricting content and designating someone as the arbiter of truth is not a feasible solution. Now, in response to your question, what is the prime area of concern? Personally, I think if you look at what has brought this issue to the public and crystallized it as a thing, I think it has been potential impacts of fake news on electoral processes. This is me speaking personally. That is my perception of what has really raised the alarm bell. So citizens need to have reliable information in order to exercise their civic and political rights. So I think that is the prime concern, although there are certainly many others. At a sort of meta level, fake news, I think, contributes to a coarsening of public discourse. It creates a kind of anxiety in the public and possibly a sort of cynicism and feeling of powerlessness potentially about whether there is in fact truth that can be accepted, whether information is reliable, and there are consequent impacts on trust of institutions, political actors, and the media. So that I would say that is a prime concern, which is motivating the public about fake news.
Thanks. Any last? I guess we're towards the end of the session. Yeah, we would have another 10 minutes. Does anybody have any questions left? Everybody happy? Then I will, if anybody wants to make some last statements, or you're all fine. If not, I have basically a provocative question to Glyn to finish with.
Good, I like provocative questions.
Is there any scenario in the world under which you might think, general content filters would be permissible and actually a good thing?
No.
I second that.
It's really the wrong answer. This idea about looking at the broader issues and training judges is such a difficult, messy solution. Politicians don't want to think about it. They want an easy solution to say, technology will solve it. What's the problem? But really, it's as we all know, it's such a hugely difficult problem. It requires a hugely difficult answer. And I really think we must defend our legal system. At the moment, we're undermining it, and that's very worrying.
Right, thank you, and thank all of you for sitting through this. I think it's the last session of the day before we go have a drink. I hope towards the end of the session it made a little bit more sense for you how all these different things actually come together, because at the beginning I think a lot of people ask me, so what, hate speech and then fake news, and then we have copyright, and then we have here something about the UK and doing notice and takedown. How does this play together? But in the end what we're seeing is that there are a lot of efforts to control content, and it's something we need to deal with no matter what the content is. So thank you.
Thank you.